I'm reading the matter of Green Charitable Trust from 1988, opinion by Justice Hood. Respondents, Comerica Bank and Miles Gaff. Appeal as a right from an order of visiting Oakland County probate judge George Benko, which removed respondents as trustees of the Leslie H. Green and Edith C. Green Charitable Trust, removed Comerica as personal representative of the estate of Edith Green, deceased, and surcharge respondents in the amount of $1.9 million. The petitioners are the Michigan Attorney General, St. Peter's Home for Boys, Bishop of the Episcopal Church Diocese of Michigan, Dean of the Cathedral Church of St. Peter and the Cathedral Church of St. Paul. This case is based on the petitioner's objections to respondents' sale of real property owned by the estate and charitable trust to Maurice Cohen, a client of respondent Jeff. Leslie and Edith Green owned and maintained a residence on 315 acres of Bloomfield Township, Oakland County, known as Turtle Lake Farms. In 1969, Leslie and Edith Green created a charitable trust funded in part by a grant of an interest in Turtle Lake Farms. As finally amended, the beneficiaries of this trust are St. Peter's Home for Boys, the Cathedral Church of St. Peter, and the Cathedral of the Episcopal Church Diocese of Michigan. The named trustees were the Greens, Comerica, and Miles Japp. Mr. Green died in 1973. His will gave Mrs. Green a life estate in the portion of Turtle Lake Farms, including their residence, and created a marital trust for the benefit of his wife during her lifetime. The charitable trust was made the residuary beneficiary of the marital trust and received the marital trust's interest in Turtle Lake Farms upon Mrs. Green's death. Comerica was named sole trustee of the marital trust. Mrs. Green died in March of 1983. Her will made specific bequests totaling $320,000 and directed the establishment of $1 million trust for her granddaughter. The residue of her estate was left to the charitable trust. Mrs. Green's estate consisted of cash and securities valued at $1,340,000 plus her interest in Turtle Lake Farms. Comerica was designated personal representative of the estate. Upon Mrs. Green's death, Bishop McGehee and Dean Herlong of the Episcopal Church became co-trustees of the charitable trust as provided for under the trust. Under the trust, only Comerica and Jaff were empowered to make decisions regarding the disposition of real property. According to respondents, soon after Mrs. Green's death, they determined that the liquid assets of the estate were insufficient to satisfy the cash bequests, the funding of $1 million trust for the granddaughter, the estate taxes, and the administrative expenses. After reviewing the options, Comerica and Gaff concluded that the interests of the estate and its beneficiaries would be best served by the sale of the Turtle Lake property. At Mrs. Green's death, 3 entities owned individual interests in Turtle Lake: the Edith Green estate, the marital trust, and the charitable trust. For the sale, Comerica acted in 3 capacities: as executor of the estate, as sole trustee of the marital trust, and as one of the trustees of the charitable trust. Gaff also acted in several capacities. He was a trustee of the charitable trust. Also, Jeff and his firm, Honigman, Miller, Schwartz, and Cohn, were attorneys for the estate. For Comerica as executor, for Comerica as trustee of the marital trust, and for Comerica as the trustee of the charitable trust. The record also contains testimony of Dean Herlong to the effect that Jeff, as at least on one occasion, provided legal advice to him in his role as trustee. Jeff had been personal friend of the Greens, as well as their attorney. He drafted their wills and the trust instruments. During the time between Leslie Green's death and the death of his wife, Comerica Trust department received inquiries from individuals interested in purchasing Turtle Lake Farms. Since the intent was for Mrs. Green to live out her life on the property, Comerica informed inquiring developers that the property was not on the market and that they would be notified when it became available. The parties' briefs described in detail the events following Mrs. Green's death and leading up to the sale of the homestead, the real property concerned in this action. The homestead is the western portion of Turtle Lake property, consisting of 211 acres and including the Greens mansion and other buildings, Turtle Lake and lakefront property on Upper Long Lake. On September 15th, 1983, Comerica accepted an offer from Maurice Cohen for the homestead. The sale was closed on November 1 of 1983 by execution of a land contract for $3,250,000 with $1,500,000 down payment and the balance over 2 years at 12% interest. Maurice Cohen is a successful real estate developer and was represented by the Honigman firm. This case concerns the objections by the charitable trust beneficiaries to Gaff and his law firm's conflict of interest in representing both the buyer and the seller. To Comerica's management of the sale of property and the adequacy of the price received for the homestead. Testifying for Comerica were Jerry Kirsten and Cleveland Thurber. Kirsten was vice president of Comerica's Trust Real Estate Department, which supervised the management of Trust Real Estate, and the Comerica representative who apparently worked most closely with Jeff on the sale of the property. Thurber was in charge of Comerica's Trust Department, which generally oversaw the trust, and one of the trust officers who participated in decisions to sell the property and to accept the Cohen offer. Other Comerica employee, the sales manager, Mr. Keating, apparently supplied information to Kirsten on the value of the property. David Wind was another trust officer involved in various decisions. Neither of these two men testified. Leo Marzels, who had done an appraisal of the property in 1873, was retained by Comerica following Mrs. Green's death as part of the efforts to prepare a marketing plan and as a consultant to assist in evaluating the value of the property. Calvin Hall was retained to submit a development plan on the possible uses of the land. Donald Tilton was retained to study possible environmental problems caused by the wetlands on the property. Also testifying was Paul C. Robertson, a local and land developer and builder who had expressed interest in developing the property prior to Mrs. Green's death and who contacted Comerica regarding the property again in May of 1983. The Attorney General is a petitioner as a necessary party in interest to estate proceedings involving charitable trusts. Maurice Cohen visited the homestead in April of 1983 and expressed an interest in purchasing the Green residence and the few surrounding acres. Kirsten told Cohen that the sale of such a small parcel was not desirable because it would reduce the marketability of the balance of the property. Gaff put Cohen in touch with Calvin Hall and showed Calvin Hall's development plan to encourage Cohen's interest in a larger parcel. Throughout the summer, Gaff continued to meet with Cohen to encourage him to make a suitable offer for the entire parcel. According to Gaff, when he realized in August that Cohen was interested in making a hard offer on the entire homestead, he informed Thurber that there was a potential conflict of interest because his law firm represented Cohen. In the letter of August 12 to Thurber, Gaff requested the consent of Comerica, Bishop McGee, and Dean Herlong as trustees to the Honigman firm's dual representation and indicated that in any event, Gaff would not act as co-trustee with respect to any offer by Cohen. It does not appear that Gaff sent copies of the letter directly to Bishop McGee or Dean Herlong. On August 18th, at a meeting of Comerica representative and Honigman attorneys, Marzels expressed his opinion that the homestead should sell for between $3 million and $3.5 million. On August 22, all of the trustees of the Charitable Trust met to discuss the possible sale of the land and the question of dual representation. Dean Herlong testified that Thurber informed them of the estate's cash needs, and Gaff discussed the various problems with development of the property. Schaff, Thurber, and Kirsten also informed Bishop McGee and Dean Herling that they expected Cohen to make an offer for the western portion of the property. Gaff explained the conflict of interest. Former Chief Justice G. Menon Williams was also present at the meeting in his capacity as senior warden of the vestry of the Cathedral Church of St. Paul, but he did not testify at the trial. Dean Herlong testified that the Chief Justice was present at the meeting, was present at the dean's request. The senior warden is the representative of the cathedral to whom Dean Herlong is ultimately responsible, and Dean Herlong felt it was in the best interest of the cathedral for the Chief Justice to be present. The Chief Justice was precluded from practicing law, and we find no indication in the record that he was present as or in any way acted as a legal advisor. On August 23rd, Cohen made an offer for the homestead of $3 million. Neither the price nor the conditions were acceptable to Jaff or Comerica, and Kirsten directed Jaff to go back to Cohen to see what could be done to better the offer. On August 26th, a one-page circular describing generally the land and its availability was sent to people who had expressed interest in the property and to local real estate people. Kirsten authorized the mailing against the advice of Gaff. On August 31st, 1983, Bishop McGee and Dean Herlong sent a letter to Gaff consenting to the dual representation subject to the satisfactory demonstration by the Comerica Bank after reasonable investigation that the offer is indeed suitable, appropriate, and keeping with the present market situation. Okay, so couple things. There we go. Marketing and consent with terms. On September 6th, Kirsten met with Robertson. Kirsten apparently attempted to secure an offer on the entire parcel from Robertson, indicating that the asking price was $10 million, with $4 million down. Kirsten met with Cohen on September 12th, apparently in an attempt to secure a better offer and to obtain an extension of Cohen's offer, both of which Cohen refused, and a revised offer of $3.25 million was prepared by the Honigman attorneys and accepted on September 15th. On September 19th, Dean Herlong was informed of the sale. On September 26th, Wynn, Kirsten, and Jaff met with Dean Herlong, Bishop McGee, and Chief Justice Williams. Dean Herlong testified that he expressed at this meeting his concerns regarding the sale of Comerica's marketing of the property. The Cohen deal was closed on November 1, 1983. Bishop McGee and Dean Herlong signed the land contract as trustees of the Charitable Trust. Dean Herlong testified that Jaff told them that the sale was a fait accompli and that their signatures were a legal formality. And on December 29th, Gaff wrote to Bishop McGee and Dean Herlong advising them that another Honigman client was interested in another part of the property and requiring their consent to the multiple representation. In the letter, March 5th, 1984, Dean Herlong consented to the multiple representation, but asked for an appraisal of the property before sale. According to Gaff, Dean Herlong indicated for the first time that he was dissatisfied with the way in which the Cohen sale had been handled. Dean Herlong testified that he had orally conveyed his dissatisfaction earlier. After the present controversy arose, appraisals of the market value of the homestead as of September 15th of 1983 were prepared by Maisels, who was selected by Gaff, and by Proctor, who was selected by Dean Herlong from a list of appraisers submitted by Gaff. Over Dean Herlong's objection, the instructions to the appraisers included information on the Cohen sale. The appraisals were completed in 1985. With Maisels indicating a value of $3.35 million and Proctor arriving at a value of $5.15 million for the homestead. On September 9th of 1984, St. Peter's Home for Boys filed a petition and objected to the account. On December 2 of 1985, the Attorney General filed a similar petition. On November 12, 1986, Bishop McGee and Dean Herlong filed petitions in the probate court pursuant to MCL Section 700-805 to surcharge Comerica and Jeff as trustees of the Charitable Trust, and the Attorney General filed a petition to surcharge and remove Comerica as executor of the Edith Green estate, as trustee of the Marital Trust, and as trustee of the Charitable Trust. On November 13th of 1986, Judge Benko began hearing on all of these petitions, excluding issues relating to the Marital Trust because Comerica had been discharged as trustee when the Leslie Green estate had been closed in 1984. Following several days of testimony, the probate court issued its 34-page opinion finding that Jaff and Comerica violated their obligations as trustees to the settlers and beneficiaries of the Charitable Trust, and that Comerica violated its obligation as personal representative to the Edith Green estate. As to Comerica, the court found that it had negligently handled the sale of the property as evidenced by its inadequate offers to determine the property's value and its failure to adequately market the property. Furthermore, the court found under negligently handled the sale of the property, inadequate efforts to determine the value, and failure to adequately market it. Furthermore, the court found that Comerica was negligent in its response to Gaff's acknowledged conflict of interest and in allowing Gaff and his firm to control the negotiations. As to Gaff, the court found that his conflict of interest, although acknowledged, tainted the sale because there was not full disclosure of the extent of his prior representation of Cohen on personal tax matters, because Gaff actively participated in the negotiations, and because his course of conduct ensured that his client Cohen obtained the property at an inadequate price. The court found that both parties had failed in their duty to keep the beneficiaries reasonably informed and to fulfill a self-imposed duty to keep their co-trustees fully advised of the developments. Now we turn, there's a couple duties going on here. Failing of this duty, not full disclosure, conflict of interest, about the conflict of interest happening. We now turn to the substantive issue of whether Gaff and Comerica violated their duties to trust. As a preliminary matter, we note that while Gaff maintains that he declined to act as a trustee with respect to the offer by Cohen, he did not resign his position as trustee. Therefore, his duties to the beneficiaries and the trust as to matters related to the valuation and marketing of the property did not end when he chose to decline to act on the offer. Paragraph 7 of the trust gives the trustees broad powers to do everything they in good faith deem advisable, even though it would not be authorized or appropriate for fiduciaries, but for this power under any statutory or other rule of law. Paragraph 5 empowers Comerica and Jeff in their sole discretion to determine the timing of any sale of the real property so as to realize its full value. There's 2 more pages, 4 more pages, 2, 4, 6, 8 more pages. So I'm going to pause here at the beginning of page 536.